Hello, hello, and hello. Welcome back to another episode of The Family Fortune. It's me, Lashana. Malcolm's over that way somewhere hiding. But we do have a very special guest today as we talk about some of the costs that are normally associated with estate planning. So please welcome Miss Attorney Melody Ebron.
Hello, hello, hello.
And I have the honor and the privilege of actually working for her. So
With me.
me. And this is a subject that we've been talking about lately, estate planning, because we want to start diving a little bit more deeper into it. But as I was doing a lot of the research, one of the things I noticed is there's a lot of hidden or not so hidden costs that are associated with estate planning. Like, off the top of your head, which ones? One of the biggest issues with estate planning that comes to mind when I say that is what?
Filing costs.
Filing costs. But I was actually going, that's one of them. But where I was going with is not having one at all.
Yeah.
It's not necessarily a financial cost, because there is some finances involved with it, but there's a lot of costs, and I'm saying quotation marks, because you have a lot of time costs, emotional costs,
right,
that comes with not having a plan. So what are some of the big issues that you think can come up that you can think of? I can think of a few of not having an estate plan besides filing.
Right. So not having an estate plan, one way or the other, your family or your loved ones can miss insurance benefits. They can spend too much money on services. They can not know about some of your desires and end up spending too much money on those services. So, I mean, the big thing is knowing what the assets are that I actually own or they may own, and how you need to come about getting them.
Right. Like you said, there's the filing cost. One thing that comes to mind when I think about it is, especially if there's a big family or a lot of siblings or, mom and dad, whomever, is the disputes that pop up, especially if there's no plan.
Right.
There's always somebody going to be fighting, well, so-and-so promised me this and so-and-so promised me that. Big mama said I can have her shoes and her hat collection or what have you. And then there's a big, big fight. And then families get torn apart because of it.
Oh, yeah.
That happens, right?
You have some siblings that stop speaking after a parent dies.
A long time.
Yeah.
So there's an emotional toll that, or emotional cost that comes with not having an estate plan. And again, the biggest one, though, is the probate process.
Correct.
So kind of walk us through what kind of happens if you don't have an estate plan and some of the costs that may be associated with that.
So if you do not have something in, when we say estate planning, first off, I mean either having a will in place or some form of a trust.
Right.
So estate planning meaning you have designated and lined up how you want your estate, meaning your assets and anything you own, to be distributed once you pass away. So if you do not have anything in play, guess who gets to answer all those questions? The state. So you have a probate judge, and they're great. I love our probate judges here in Richmond County, but they may not know you individually. So, but they get to make that final say to say how Big Mama or whoever wanted to distribute their final assets. So that's the number one cost. Is the fact that someone else is going to make those final decisions for you.
Wow. I'm glad I have an estate plan. I know he's not going to answer, but you can nod your head. Do you have one, Malcolm? I thought we're gonna talk to you after this. We're gonna talk to you after this. But there are also some issues, like you have a plan. You have either a will, you have a trust, you have insurance, you have power of attorney, you have all of the things that are normally make up an estate plan. But there's still costs associated with that. And a lot of people don't think about another one. There still is some kind of filing cost.
Right.
There are still filing fees. So a lot of people, especially if you have a will, it has to go through probate.
Yeah.
And there's going to be fees. And depending upon where you live, those costs are different.
That's correct.
And it's not instant.
That's correct. And you also have within filing costs, you have publishing costs, because
That's right.
you have to put the world on notice that someone has actually passed away. So don't think just because you have a will that it's something nice and quiet and, oh, well, they had a will, so we know this person is over the will, so they just take over and start distributing things. No, you still have to go through probate court, and you still have to put the world and your creditors on notice.
So if you still, if a person dies and they still have bills, that outstanding bills, credit cards, what have you, they get to come in and say, hey, don't forget about me, right?
They can. Now, whether or not they get anything is another question, but
but they at least have the opportunity to say to be able to do that. And so we're not going to get into the pros and cons versus wills and trusts, because that's
a whole nother subject,
another rabbit hole we ain't got time to go for. But one thing in my research, what I found was, and a lot of people don't think about this, is if you create your will and or your trust and say Alabama, but then you move to Georgia, that's a difference.
Totally different.
So the laws of Alabama will not apply.
That's correct.
It would be the laws of Georgia.
That's correct.
And so there's such things that, what you thought you may get away with for free or not have to pay in Alabama.
In Georgia, you're going to pay.
In Georgia, you're going to pay. So that's one thing I always tell, we should remind people is, if you move from one state to the next, maybe redo all your documents. And that's another cost altogether, because now you have to pay the fees to get someone else to redo all your plans.
Correct. And one thing, just as a note, somewhat, I would say every maybe every 3 to 5 years, review all of those documents. Other people passed away. They may have been listed as beneficiary. Maybe someone had a new child, and you need to add them in. So you need to review all of those policies, maybe make any contingencies, change whatever you need. So review those things every, I say, 3 to 5 years.
Yeah. And if nothing changes, correct, every 3 to 5 years. I agree with every 3 to 5 years. But definitely if something does change.
Yes.
Like if you get married, you get divorced. Because one thing I remember in the military, and they finally made changes to it, was people would get divorced, husband and wife would get divorced, and we have what's called SGLI, which is the life insurance or beneficiary plan, what have you. And they would never change it. So someone would get divorced and they would remarry. And then, unfortunately, the soldier passed away.
And then the first wife
got
gets
everything.
Wow. Yeah.
And so, but they kind of changed. When that happened one time too many, they changed it so that, one, you can't disown or not leave it to the current wife without them having a say-so. And then, two, they said it where you can't send it to the previous wife. Once you get divorced, kind of goes away. So that was a good thing. But that brings us to life insurance. The life insurance you may have paid for back in, let's say, 2010 may not be good enough anymore.
That's correct.
Because life be lifing, and it's expensive right now. So the $25,000 life insurance policy that you bought in 2010
may only cover the casket.
Maybe not even that. The way everything is costing these days. So that goes back to what you said. Just make sure you review and update everything that you're looking for. Same thing with the beneficiaries. If someone passes away, someone leaves, you have a falling out, y'all not talking no more, make sure you update those. One thing that I noticed as a notary and having to go into different places, different homes, especially after someone dies, is the people don't know where stuff is.
And that's a huge cost.
You don't know what you may be missing out on.
Right. Or you may not know that they even have a will, or that they have these documents in place if they never told anyone.
Right. So they're looking in all the drawers, all the cabinets, no
everywhere.
Clue of where stuff is or how to find stuff. So keep everything kind of all together.
Right.
And if possible, give it to whoever you name as the executor or the beneficiary, so they'll have it.
Right.
And hopefully they won't put it in with their in their junk drawer.
And you can always utilize the court system or the clerk's office and have it filed too. And at least someone will have a copy of it. If you went through an attorney, of course, they should have a copy of it as well. And then for some of the documents, say your healthcare documents, your physician should have those. And you can always here's another cost, spend some money and actually utilize a safe deposit box at your bank. And all of the documents can be there.
That was the conversation we were having earlier today on the phone where I was talking about payable upon death forms. And you have to know that sometimes the same thing is titled different ways. But those are the forms from the banks and your financial institutions. Some of them call them, what did you say? Call them beneficiary forms. So you have to make sure those are on file. A lot of people forget about that. Because what happens if they don't have either a payable upon death form or beneficiary form on file?
It sits there. It will sit there depending on the institute. I'm not sure how long. But in order for the heirs to get access to it, they definitely will have to go through probate.
Okay.
So
it becomes part of the probate.
Correct.
Even if it's... No, I don't think so. I'm going to say even if it's part of a trust. If it's part of a trust, it's something totally different.
Correct. Because it's designated if it's part of the trust. But if it's just out there and not covered, and maybe it's just mentioned in the will, then, of course... Once they probate the will, then that will become part of that estate. And then, however, in the will they wanted to designate the money, divide in half or whatever, then it's divided. Okay.
One of the big issue is, since we're starting to go into trust, is people will create a trust and they don't do the one thing that they should do that makes it a valid. Well, the trust is valid because the trust is just a piece of paper. Let's just be clear. It's just a piece of paper.
Right.
That lists certain things. But it's no good if there's nothing in the trust. So, and when I say nothing in the trust, you can say, okay, I want to put my house in the trust, I want to put my car in the trust, my bank account, whatever. And that's well and good on the piece of paper. But what happens if you don't actually move the stuff into it?
Right.
That's one of the big issues.
Right. Then nothing happens. Then it technically is not part of that trust if you don't do the second step or the final step and actually transfer everything over into that trust.
And that's a cost too.
It is.
And that is a cost too, because we're talking about what I call it funding the trust, because you're putting the assets in the trust, and that includes doing deed transfers, which is a cost. Doing title transfers, which is a cost. And then the cost itself for doing that, and then 9 times out of 10, you're paying either an attorney or an accountant or both.
Right.
So you have to consider all those costs as well when it comes to dealing with your estate plan, creating your estate plan. That's why I know some people are on the fence about will or trust. And for me, in my head, it just means you either paying now or you're paying later.
Right.
That's the difference to me. One of the final things is when I saw this note in the when I was doing my research, it actually said naming children joint owners gives creditors access to any funds that you left them. And I was like, I was puzzled over that for a minute. I was like, what exactly does it mean? And help me out if I'm saying it, if I'm clarifying it wrong, but that just means that if someone leaves me and my sister, like my mom, she leaves me and my sister jointly the house that she currently has, any creditors that I have can now go against her house.
That is correct.
Wow. So what?
Because that's now
my asset.
Your asset.
Huh. The things you learn every day. So that's something also to consider too. So it doesn't even, whether you have a will or you have a trust, naming people joint acts, putting things into your name can also open up a whole can of worms that a lot of people don't think about. And so then if they can also go against my sister then, huh?
Correct. And that's why a lot of times too, when someone passes away, family members may want to keep that asset in the estate's name, just so that they're not affected by their own creditors. So in essence, they still keep it in the estate, but now my creditor can't touch it. So things that are in my parents' estate, because that belongs to the estate and not me personally, they can't go after it.
That's good.
So, yeah.
And that helps to, that kind of information helps to when it comes to naming whoever's going to be the executor or whoever's going to be the trustee or whoever's going to be the beneficiary. Because you don't want Cousin Jim Bob down the road who got all kind of stuff going on in his life and people knocking on the door in the wee hours trying to repost some stuff. You might not want to consider them. Right. So I encourage people to do a good assessment of who they name as someone over their family estate or their estate. So before we close out, any other last thoughts or things we should consider when it comes to estate planning? Except have one.
That's the main thing. Just get it done. Get it done. And if you don't know, ask. Don't be afraid to reach out and just say, hey.
And that's a shameless plug for the Ebron Law Firm.
That is true. But, reach out to me or anyone else. The thing and the key for our community is definitely to move towards getting something done and something in place. We see all of the GoFundMe, requests. Mm-hmm. You won't need that GoFundMe if you make those preparations for those costs beforehand. So, it's important. Just get something done, something in place, and don't leave a question mark. Don't leave a question mark for your loved ones to have to answer these questions,
And whether you have a lot or a little, have a plan.
Correct.
Because it's just me and my son, and I have no assets like that. But I was like, what's mine is now yours.
That's correct. And you have something. You have something.
Yeah. So he'll get the rusted cookware that I never use anymore, and all the
not rusted.
Stuff.
It's brand new.
Never use anymore. But I thank you so much, and we're gonna talk. Well, of course, we're gonna have you back again, talking about something else. I don't know what yet, but are you paying attention? Until then, I'm Lashana, and this is our guest,
Melody Ebron,
and Malcolm's on the keyboard, and this is Family Fortune. Say goodbye.
Goodbye.
Bye.